Judge, as we're coming up, Ms. Schlax, I believe, is already in agreement with this, but just for the court, there are two restitution orders in Mr. Whitaker's case. One is for $1,200, and that is for Ms. Buckley, damage to her glasses and loss of her cell phone. And there is a $7,500 restitution order that is to victims' crime compensation, and that is for funeral expenses that were paid out. Now we'll have some restitution orders in Mr. Robinson's case.
Okay. And so, to be clear, Ms. Schlax, no objection to these two restitution orders?
No legal objection, Your Honor. As to the second amount of the $7,500 of the funeral expenses, I assume it will be jointly and severally liable with not only Mr. Hakeem Robinson, but Mr. Dominique Varner, who has entered a plea in this case, admitting his involvement, as well as Abdul Robinson Sr.
And the restitution orders do reflect any money paid by any other responsible co-defendant. We'll go towards that as well.
Okay. I'm not sure if Senior is considered a co-defendant necessarily in this case for him to share in that expense. Perhaps he is, I don't know. I'm not making that determination today.
Certainly.
Also, just to be clear, these have to be submitted electronically. I'm not signing these. That's the new policy from your office and ours.
I will have
So
it electronically.
you'll need to submit those electronically for my signature. Okay. Anything else? Mr. Whitaker, do you wish to say anything? Okay. All right then, Mr. Whitaker, of course you sat through the trial, as did I, and on July 31, this jury did find you guilty both of count 1, murder in the first degree, and count 2, burglary with an assault and battery. A unanimous vote by the jury. And so today I will voice, but to sentence you as required under the law to a mandatory term of life in prison without parole. You will get credit for 1,995 days already served. As to count 2, the burglary with assault or battery, that is a first-degree felony punishable up to life. And this court does find that what Ms. Buckley experienced and sustained merits a sentence of life in prison as to count 2. That will run concurrently with count 1 and with credit for 1,995 days already served. I will invite $18, a $150 total appointed attorney's fee. A restitution order will be entered against you jointly and severally with your co-defendants as to $7,500 to the Victims' Crimes Compensation Trust Fund, $1,200 payable to Ms. Buckley, and that will conclude the sentence. You do maintain the right to appeal both judgments and sentences that I have imposed today. And if you cannot afford an attorney for that appeal, one can be appointed to you. But a notice of appeal must be filed within 30 days. Do you understand that?
Yes.
Okay. Is it?
And Your Honor, we are prepared to file that today.
The notice of appeal?
Yes.
Okay. Do you need me to appoint counsel then?
I would ask at this time. His family may elect other arrangements in the future, but I would ask for that at this time.
Okay, then I'll appoint, at this juncture, I have to start with the Office of the Public Defender for purposes of appeal. Do you understand your sentences?
Yes.
All right, sir, that's going to conclude your case today. Oh, what is happening? Hold on, bring him back. He's got 2 other matters that are pending on the court's docket. What do the parties want me to do with those?
Judge, I'll announce a null pros code 30 on both of those.
On both of them?
Yes, Judge.
Okay. Your other 2 cases have been dropped by the state. Thank you. All right. Then moving on to Mr. Hakeem Robinson. Is there any evidence that the defense wishes to present on behalf of your client?
No, Your Honor.
Any evidence from the state other than the victim impact that we've already heard?
No, Judge, and I will similarly submit a restitution order of $7,500 for victims' crime compensation for the funeral expenses. One other matter with regard specifically to Mr. Robinson, which I did discuss with the defense counsel, the state is going to ask the court also impose an increased cost of prosecution in relation to his case, and I have an amount of $62,159.29, and that is the amount of money that the state paid to the experts in this case, the digital experts, which testified at trial in the Daubert hearing, and all the analysis that they did in this case, and I have shown that to defense counsel as well. I don't believe they have an objection, but I'll let them speak to that.
We would have went to that, Your Honor, just given the fact that we did file a dollar motion. We did not think that either the expert or what was testified to were admissible, and we also took issue with the great cost of the spend.
All right, well, there being an objection, then we need to have a hearing on that matter then. Do we not?
Judge,
I mean, also understand, if I order these costs and the appellate court tells me I'm wrong, that those experts shouldn't have been admitted and I was incorrect in my double here, obviously you would not then be, or your client would not be responsible for those costs. Those would be backed out of any costs of prosecution that have been ordered. I don't know if that would suffice for this, otherwise we'll need to have a hearing and I'll need to hear evidence and testimony to determine whether that is a correct and accurate amount as we sit here today.
Please, Your Honor, yes.
Okay. All right, then I won't at this juncture order costs of prosecution, but we'll need to pass that for a hearing on another date. Okay. Do you wish to make any argument? I don't know. I'm looking at the two of you. I don't know which one's going to handle it. Ms. Kawas, Mr. DeCoste?
Argument as to,
There being no other evidence, then if there is anything you wish to argue on behalf of your client.
Judge, just understanding that he is just facing the one count.
Correct.
And there is, and I have discussed with my client that the court's hands are tied. And it's a mandatory sentence that must be imposed. So at this time, before the sentence is imposed, we have no legal argument.
Okay. And I always give every defendant the opportunity to speak if they wish. Mr. Robinson, is there anything you wish to say? Okay. Anything the state wishes to say?
nothing additional, Judge.
Okay. All right, Mr. Robinson, if you'll come forward for sentencing. All right, Mr. Robinson, again, on July 31 of 2025, the jury found you guilty as charged in count 1 to murder in the first degree by unanimous verdict. And at this time, this court will then adjudicate you guilty of that offense and sentence you to the only lawful sentence that this court can impose, and that is mandatory life in prison without the eligibility for parole. You will have credit for 1,666 days of time already served. I'll impose mandatory felony court costs of $518. I'll enter a restitution order payable to the Victims' Crimes Compensation Trust Fund, which will be joint and several with your co-defendant, in the amount of $7,500. Do you understand your sentence?
Yes, ma'am.
Now, of course, you do maintain the right to appeal both the judgment and the sentence entered in this case, and you, if are going to do so, must do so within 30 days. If you can't afford an attorney for that appeal, one can be appointed to you. Do you understand that?
Yes, ma'am.
Okay. Are the parties requesting at this time appointment of counsel, or is he going to retain counsel for the appeal?
Your Honor, at this time, he is going to be exercising his right to appeal, but at this time, we'd ask you to appoint counsel for appellate purposes. You will, of course, have advised him if he desires to retain counsel, he can do so at any time.
Yes. Okay. All right. That will be done. So do you understand your sentence?
Yes, ma'am.
All right. Now, Mr. Robinson also has one remaining case, 2021 CF 2332, for another count of murder in the first degree. What is the intention of the parties for that matter?
Judge, I think we need an additional pretrial date for that case, and perhaps
Okay.
we could also address the hearing on the cost of prosecution at the same time.
All right. When do y'all want to come back for both of those things?
I'm available anytime, Judge.
Okay. I'll look to the defense then.
Your Honor, at the moment, I'm going to be in trial and have the entire month of November.
Okay. Is there any time this month in October that you're available?
Yes.
I mean, I'm available next week or the week after. I have no trials for the next 2 weeks, and have some limited availability the week of October 20th. This shouldn't take but I don't know.
Candidly, I don't know what then prep we would have for, we were just advised of this morning about the state.
Okay.
Have some sort of accounting of how they're coming to those amounts. Whenever it is that we receive those items and we give clarification, I just want to
Do you have that itemization, Mr. Cooper?
I do, Judge.
All right, why don't you provide that to the defense then?
That's different than this fact.
Your Honor, I'm available the week of the 20th if the court wants to set it then.
Okay.
I just want to make sure Mr. DeCosta is well.
Right, and we can do date, time certain since I know you all are, are you appearing in person or do you wish to appear on Zoom?
It'll probably be by Zoom, Judge.
Okay.
That week works for me as well, Your Honor.
Was that the week of the 20th, Judge?
The week of the 20th?
Any day other than the 20th is...
Okay. Do you want to do Friday the 24th? Does that make it easier? I can do 10 o'clock. I already have a 9 o'clock.
Yes.
Yes. And Your Honor, is it possible, I've explained to my client what entails. He doesn't wish to be present for that. Could we waive his appearance for that?
Well, his...
Or did he need to be present for the restitution hearing? Well, no, it's just...
For cost of prosecution hearing?
Yes, Judge, I discussed with him, he says he doesn't wish to be present, so if we could have his appearance waived for that date.
Well, if that's what he wishes, then he doesn't need to be here. I don't even know, well, I guess he would not be transported to prison yet given the pending case.
Right, which is
But-
both going to be on.
Yeah, we would do the pretrial in the homicide.
Hey gang, you know what opinions is, man? I'm just back on another video, man. Can you see on this video, man? It's Ksoo and Scotty, man. Their trial still continuing after they built guilty on first degree, man. You know, man, Ksoo he been Yungeen Ace member since from day one, you know. So they just caught the body, so they just sentenced to 15 years in prison and over 89 bond. You know, man, Ksoo, man, he been moving reckless on the street after his father testified against him. You know, man, his father, he say, man, Ksoo, he done everything, man. He just been running around, man, don't wanna tell the truth. But you know, ATK Scotty, man, he been like keep it real with Ksoo, man. He never testified against Ksoo. That is why he just received some sentence in the prison too. And he also bleeding on first degree, man. You know, man, Ksoo and Scotty, man, they used to be around Yungeen Ace from back in the days, like from the jump, you know. They've been in ATK, man, they be running some different things. So just make sure just stay tuned every time that drop video be straight. So you know, man, it's sad day, but you know, man, it is what it is, bro. So Ksoo just go and serve 15 years in prison, and also Scotty go serve 15 years in prison. So just make sure just stay tuned every time I drop video be straight, and make sure you just like, comment, and subscribe. Make sure you go share with your people. So I'll catch you on another video. I'm out again.